Pfizer Cost Action for letting me be part of the working group one. I'm going to talk, as Nicolas said, in 20 minutes about the legal regulation of carpooling with a special reference to BlaBlaCar, and I will try to deal with the main issues that this topic arise. Well, the consolidation in the economic traffic of virtual platforms dedicated to the transport of people is at the present time an indisputable fact. The arrival of BlaBlaCar in France in 2006 or Uber in the streets of San Francisco in 2009 was just the beginning of a different way of conceiving the intercity and urban passenger movement. Virtual platforms represent a new challenge for the legislator and, of course, for operators rooted in traditional service delivery mechanisms. In the intercity field, the high frequency of journeys on offer, the time flexibility, collection at meeting points that are closer than trains and bus stations, and above all, a lower price are just some of the advantages that users appreciate when opting for carpooling over standard means of transport, like trains, buses, cabs, etc. Generally speaking, it can be held that these alternatives to traditional transport services increase users' options, encourages competition, and makes private property profitable. From another perspective, the proliferation of private vehicles in a previously reserved area has triggered a reaction from the sectors concerned. The latter have highlighted the lack of control over new providers. The lack of control implies, of course, a flight from the obligations imposed by regulations, and in this specific area, these obligations are multiple and varied in nature. For example, commercial, administrative, tax, labor, and so on. Well, having said that, carpooling can be defined as a form of travel in which several people share a vehicle in order to jointly cover the expenses involved in the trip. Thus, the fact of sharing a vehicle to make a certain journey, generating a community of expenses among the passengers, is at first one of the best examples of the so-called collaborative economy. The numbers of carpooling are really impressive. BlaBlaCar, the main carpooling platform, has more than 80 million users, including 5 million users in Spain. Also, Amovens, another Spanish company, which was born in 2009 as a carpooling community for companies and universities, and which in 2016 added to its services car rental between individuals and renting for individuals, brings together 1.5 million users. Well, let's talk now about the main problems that carpooling can bring forward. First of all, the activity of the carpooling companies. Are they land transport companies? Well, the activity of carpooling companies consists of connecting drivers and passengers who intend to make a certain journey by means of a virtual platform and sharing the expenses derived from this journey. The companies can obtain an amount as a commission for the intermediation work done, as BlaBlaCar, or not charge any kind of commission for the service and obtain their incomes exclusively through advertising. It has been discussed in the literature and also in the courts whether carpooling companies actually provide land passenger transport service, which would require them to obtain, among other things, an administrative authorization, because if the carpooling platform were to operate as a transport company, the infringement of the transport regulations would constitute also an unfair commercial act. So if the carpooling company is really a transport company, they will have to obtain this administrative authorization, and the lack of this administrative authorization, as I said, would imply also an unfair commercial act. In the conflict between Confebus and BlaBlaCar, solved by courts in Spain, first in 2017 and in appeal in 2019, The problem, which could be extended to any entity dedicated to carpooling, focus on whether BlaBlaCar is an illegal transport company that operates without a license, without paying taxes, and in a regime of unfair competition against buses, or, on the other hand, if BlaBlaCar is a social network that complies with the regulation by intermediating and putting in contact suppliers and demanders, it means drivers and passengers, who, without profit and in a timely manner, share long-distance travel expenses. Well, in order to determine whether the activity provided by carpooling companies should be included in the transport sector, the European Commission has stressed in its communication entitled A European Agenda for the Collaborative Economy that whether and to what extent collaborative platforms may be subject to market access requirements depends on the nature of their activities. Well, if we transfer the criteria outlined by the European Commission to carpooling companies, the first criteria talks about the price. Well, the carpooling companies not establish the final price to be paid by the passenger to the driver. They only recommend a price, but the driver is free to set the final price, which can never exceed the ceiling imposed by the platform to ensure the correct distribution of the cost and the absence of profit. On the other hand, the second criteria, if the platform creates the key contractual terms, it's more complex to determine whether the companies also establish terms and conditions other than the price that determine the contractual relationship between the driver and the passengers. In this regard, it has been pointed out that elements such as the offer of an additional insurance for drivers and passengers by the platform, the establishment of punctuality rules, or the cancellation policy are not indications that could determine the subjection of the collaborative platform to the transport law. However, we cannot forget that platforms do design a series of commitments that must be complied by drivers and passengers, commitments that go far beyond punctuality rules and which this not compliance may result in expulsion from the system. In these circumstances, we believe that platforms do establish key contractual conditions that determine to some extent the relationship between the driver and the passenger. Finally, the third criteria is the ownership of key assets. The Commission asks, does the collaborative platform own the key assets used to provide the underlying service? Well, in the case of carpooling companies, the carpooling companies do not own the vehicles that make it possible to provide the service. The vehicles are owned by the drivers who, on the other hand, have no labor relationship of any kind with the platforms. In this scenario, despite the doubts that the second criteria offered by the European Commission may generate, it can be ruled that carpooling companies cannot be qualified as providers of the underlying transport service. This conclusion is radically different from the one that the Court of Justice held in relation to Uber in its ruling of 20 of December of 2017, in which Uber was classified as a transport company. Well, once it has been discovered that the companies that connect drivers and passengers in order to share a vehicle are transport companies, they can be classified as providers of information society services. This qualification is essential because the provision of information society service is liberalized. Consequently, information society services are not subject to prior administrative authorization or any other requirement having equivalent effect and may be exercised without any restrictions. Then the model of BlaBlaCar really works because they put together drivers and passengers, they create a market, they have an income derived from the commission that the passengers paid, but they are not subject to any administrative authorization. Well, let's go now with the activity of the users. Carpooling companies intermediate through virtual platforms in a market where drivers are on the supply side and passengers on the demand side. In carpooling, apart from the platform, there are two clearly distinct parties. Firstly, the driver, who owns the vehicle and sets the route and is interested in sharing the cost. And secondly, the passengers, who wish to make the route, do not have their own vehicle or do, and in any event choose the option of carpooling instead of using other traditional means of transport like buses, trains, and so on. Once it has been discarded that the platforms provide the underlying service, it is obvious that it's the driver who carry out a transport service, and in particular a road passenger transport service. Consequently, their activity must be subject to the rules contained in the transport law. Having said that, is this a case of a private transport that is not therefore subject to administrative authorization? Well, private transport is essentially not non-profit making. In carpooling, drivers offer free seats in their vehicles in order to share the cost of the journey. It is therefore an activity which does not generate any remuneration for the driver. Insofar as the amount which the driver receives from the passengers is intended to cover the cost of the journey, the driver would receive no remuneration for the transport service other than the cost savings from sharing expenses. Drivers are free to set the price within the maximum amount set by the platform. In any case, if the activity of carpooling would imply an economic benefit for the driver, he would be punished with a fine between 4,000 and 6,000 euros according to Spanish transport law. The platform, in turn, would also be responsible and fined for its intermediation. In Spain, in fact, several individuals have already been sanctioned for overcharging, and two politicians have even had to resign for its participation in BlaBlaCar when they also received at the same time money for travel costs from the government. These cases had also a cover in the Spanish media for its relevance. Well, talking about the passengers, once we have examined the activity of drivers operating on the carpooling platforms, we must analyze the legal position of those who, through the platforms, demand a transport service. Carpooling platforms are companies, so the relationship with users who are on the demand or passenger side will be governed, as could not be otherwise, but by current consumers' regulations. In any case, it should be stressed that users' complaints against the platform cannot be aimed at providing the underlying service, insofar as we have said, the platform is limited to providing an information society service. Well, this conclusion cannot, however, be drawn from the relations between passengers and drivers operating in carpooling platforms. On carpooling platforms, the providers of the underlying services are not professionals. If the drivers were professionals, we would not, in any case, be dealing with a particular private transport. On the contrary, the drivers who provide free seats in their vehicles are private individuals who offer services on an occasional basis and who take on the role of a prosumer or prosumer. This being so, and insofar as drivers are not professional service providers, it can only be concluded that in the event of a conflict, passengers would not be in a position to invoke the protective consumer legislation against them. They would only be able to invoke the regulation contained in the Civil Code. In relation to this issue, it is worth noting the system of a mandatory insurance that covers civil liability in the circulation of motor vehicles, and that platforms such as BlaBlaCar voluntarily offer an additional insurance that, among other risks, covers road assistance and guarantee of arrival at destination. Well, and just my final considerations. First of all, carpooling platforms are not transport companies, but providers of information society services. This circumstance exempts them from obtaining any kind of license for the exercise of their activity. Second, drivers operating on carpooling platforms offer a private road passenger transport service. This is a form of transport which does not generate remuneration for the vehicle owner beyond the savings made by sharing costs. Consequently, their activity is not subject to administrative authorization. Third, passengers are consumers in the relations with the platform, but not in the relation with the drivers. In fact, the drivers who offer seats in their vehicles are non-professional service providers. This means that the relationship with the passengers will be governed by the regulation of the Civil Code and not by the current consumer legislation. And finally, carpooling platforms are one of the best examples of the so-called collaborative economy. In a context such as the current one, in which the expression risks becoming a smoke screen, which in fact covers a digital economy in which professional and non-professionals, whether for profit or not, offer their products and services through virtual platforms, I think that carpooling makes possible, on a large scale, one of the purest activities of the collaborative economy. And that's all. Thanks a lot.
Thank you very much. It was